And now for our weekly look at legal issues in the news with our in-house legal expert, Attorney Tom Olson. This is Olson on Law.
Hey, Alan Spector here, and every Thursday at this time, we bring you Olson on Law with longtime Orlando attorney Tom Olson. Tom, good morning.
Good morning, Alan and crew and WFLA listeners.
Tom, our topic this morning, what does it take to challenge someone's last will and testament? Now, how often does this come up that someone asks you about challenging a will, and what do you tell them?
Alan, it comes up quite often, and I ask them to show me a copy of the will they want to challenge. I look at that copy. If that will was prepared by an attorney and signed in the attorney's office and witnessed by the attorney's staff, then it's rock solid. If that will was prepared by one of mom's neighbor and the neighbor's friends and family witnessed that will, then it is automatically suspect.
Now, even if a person doesn't suspect that technically the will is not proper, or legally speaking, do they try to challenge it on the basis of, well, I should have gotten more money than so-and-so did?
Well, remember, here in the state of Florida, you have no obligation to leave anything to your adult children, so you do have a right to disinherit them. But generally, the challenge is going to be because the person was not competent. And so to be competent to do a will, there's really two things. Number one, you have to have a general understanding of what it is that you own, what are your assets. And number two, you have to have a general understanding of who your potential heirs are, who your kids are and brothers and sisters are. And then otherwise, to make a valid will, it must be in writing, you must sign it, and there must be at least two witnesses to it.
Yeah, Tom, you said you must be competent to make a valid will. Who determines whether you're competent or not?
Well, so if it gets down to it, you're going to be in court and there's going to be testimony, usually from the decedent's doctor. Had they ever been diagnosed with dementia, any other thing in the medical record that would indicate that they were not competent at the time they signed their will.
Does a will ever expire?
No, a will could be very, very old as long as it's not been destroyed or replaced by a newer will. Doesn't matter how old the will is, it's going to be valid.
Now, a will, can you just have it at your house if it's been properly drawn up, or does it need to be filed or recorded somewhere?
Here in the state of Florida, when you sign a will, it does not get filed or recorded. So the only person having a copy of the signed will usually is the client. But in our office at the Olson Law Group, we actually sign two copies of the will. One is for the client to keep, and one is for our files as well.
Now, if you have legal questions about this or anything else, Tom will be happy to answer them on the Olson on Law show, heard Saturdays at 1 p.m. on News Radio WFLA Orlando. Just a reminder, we do this Thursday morning segment via Zoom and live on our Facebook page, and you can go back on our Facebook page and watch it at your leisure. Tom, thanks so much. We'll see you next time.
Thank you, Alan.
And remember, for all of your legal needs, call the Olson Law Group in Orlando.